I'm Asiullah Bangrawala and I shall be your host. Ladies and gentlemen, please welcome our honorable guest, Shri S. Chandrasekharan, on the stage. We welcome you, sir. Now I would like to request our speakers, Mr. Kevin Murphy from United States of America, Mr. Wilson Pinheiro Jabbour from Brazil, Mr. Padmin Buch from India, and Dr. David Ho from United States of America to take their respective seats on the stage. Now I would like to request Mr. Kunal Dalsania to present flowers to Mr. Kevin Murphy. I would like to invite Mr. Ketan Bhatt to present flowers to Mr. Wilson Pinheiro Jabbour. Thank you very much. To welcome Mr. Padmin Buch, may I request Ms. Kinjal Shah to greet him with a bouquet of flowers. To welcome Dr. David Ho, may I request Ms. Sejal Shah to greet him with a bouquet of flowers. Thank you very much. To welcome Shri S. Chandrasekharan, may I request Mr. Shoaib Masoodi to greet him with a bouquet of flowers. Thank you very much. It is my honor to introduce you to the first speaker of the session, Mr. Kevin Murphy. He manages the Asia and pharmaceutical practice for New York-based intellectual property boutique law firm GS2 Law. He's a skilled trial lawyer with over 24 years of experience that includes litigation of 24 cases to successful verdicts. Previously, Kevin was a prosecutor in the Manhattan DA's office, where he won 18 bench and jury conviction verdicts during a three-year span. He then worked on product liability litigation for Lowenstein Sandler LLP. In 2001, Kevin headed to Frommer Lawrence, making partner in 2004 after helping to win a $12 million trade secrets jury verdict for Japanese semiconductor firm Tokyo Electron. To speak on the topic inter partes re-examination in the light of our Supreme Court's Oil States Energy Services versus Greens Energy Group, I'd like to request Mr. Murphy to come forward.
Thank you very much. Okay, so. I want to say that I'm always very honored to be invited to this particular seminar. I learn more at this seminar than I do in any of the other seminars that I've attended. They are marvelously well done, very well put together, with amazing speakers. And so kudos to the Acharya law firm, to Dr. Acharya, and welcome all the speakers. I'm also privileged to be in Ahmedabad, which is my favorite city in India. I come to India fairly often, but I'm never better greeted than here in Ahmedabad. I was asked to speak on the topic of a Supreme Court case that's now pending in the United States called Oil States Energy Services against Greens Energy Group. This case is before our Supreme Court, and it is one of the landmark decisions that will affect the patent law and how patents are handled in the United States, because it will change potentially the patent reform that's been in place, the patent regime, since 2012. I'm going to throw out 4 dates. I know that we're right after lunch, and so we're not going to go into all the history here. But the first date is 1790. just at the beginning of the foundation of the American Republic. The second date is 1836. The third date is 1952, and the fourth date, 2012. Those are the 4 years in which the American Republic visited the question of patent rights in the United States. And so, within a year of founding the Republic, the Constitution had provided for patents, but there was no enabling statute. So the Congress set up the first Patent Act in 1790. They didn't revisit that Patent Act for 46 years, almost 50 years, until 1836. There were major changes to the American economy. There were major changes in the world, and the United States needed to fix some of the old patent law from the 1700s that it had in effect. And it didn't look at that patent law again until 1952, 116 years later. The United States was first to invent jurisdiction. And over the years between 1952 and 2012, some 60 years, the United States didn't look at patent law, and the world passed the United States by. The world became a first-to-file jurisdiction, and finally the United States had to do something about that and go to a first-to-file jurisdiction with respect to patents. They also tried to deal with the problem of patent trolls or non-practicing entities for those lawyers who represent the clients. And the problem was that patent litigation had become prohibitively expensive for anybody to be accused of infringement. So something had to be done to bring it back. And what was done was the creation of something called inter partes review. Now you notice it says IPR. It's not this IPR up here. That's intellectual property rights. This inter partes review is about litigation in the patent office, not in the federal courts, but in the patent office, over what the patent office had done before. And so before, it's an ex parte proceeding. That's just one party, the applicant. Now, after the grant of the patents, the patent office can look back at what it did, as long as another party accuses the patent office of getting it wrong. And so that was created by the America Invents Act in 2012. The main issue here is to reduce patent litigation. Patent litigation, particularly in the pharmaceutical area, it can cost between $16 million, $30 million, some cases are $35 million, depending on the number of patents that are involved. It is a crazy number. In addition, as I mentioned, the non-practicing entities were buying up patents continually and making sure that they got licenses to the patents there and made litigation against them prohibitively expensive. So the idea was, with the American Invents Act, that Congress, who's supposed to give out patents anyway under patent enabling statutes, setting the rules of those statutes, would allow for litigation to be conducted before the patent office, where the experts are that know the particular technology and can deal with it. And so one of the interesting things here is that it wasn't a situation where the patent office said, oh, it's only before us. It's only before us. No, they allowed for the patentee to bring an infringement case, and thereafter the particular party that was accused of infringement to send it back to the patent office. But it has to be commenced within 1 year of that patent infringement case. Now, I'll say this: I represent generic pharmaceutical manufacturers, so it's very typical for the attorneys on my side of the V, the versus, to take advantage of that. And if we mess something up somehow in the early stages, we try to fix it with the patent office, and that's been the practice. In general, as I said, it's much cheaper than federal court patent litigation. On the average, in my view, it's about 1/15 of the cost. And so it's a huge benefit for challengers, and it fixes a lot of the mistakes that were made in the granting of patents in the early stages in 1990 and so on. 2000 and so on. Okay, and there's also judicial review for this. It's subject to appeal to the Federal Circuit, where the particulars of the litigation can be gone over for procedurally as well as substantively. Okay, so how did the Oil States case happen? Well, Oil States was a patentee that had the rights to a process called fracking. Anybody know what fracking is? Raise hands. Okay, we got 4. In general, it's difficult to bring certain oils up out of the ground. And so what is done generally is an enormous amount of water is thrown into where those oil reserves are, and the drill bits don't have to go down and find just the little bits here and there. It all comes out from the water pressure and pumped up out of the ground. And so there was a process that Oil States had developed and patented, but that process was somewhat related to a prior art fracking patent. So there was a litigation, and in the litigation, the claims were interpreted. Let me get a show of hands on who knows what claim interpretation is. Again, we got 4 people, same 4 people. So let me just talk a little bit about what claim interpretation is. So in a patent, you've got certain claims. The claims say this process, this method, using this particular technique, and it's got a bunch of terms in it. Those bunch of terms have to be defined. Once the parties understand what the patent terms mean, then they can be applied to the particular product or process that is talked about in infringement. So it's either infringing or not, but generally, the parties don't know until a judge tells them that what the claim terms mean. It is the be-all and the end-all in patent litigation. Once the claim interpretation is set, and if it's a reasonable claim interpretation, the parties who didn't want to talk at all before suddenly start talking all the time. And licenses are worked out, settlements are worked out, and so it is an extremely useful tool in federal court litigation, but it's very, very expensive. So in this instance, the Oil States won. They got an interpretation that narrowed the focus of their patent claims so it didn't cover the prior art. If it covered the prior art, if it was the same subject matter as the prior art, then the invention was invalid and Greens could do whatever they wanted to. So in this case, they won. However, IPR comes to the rescue. It's done within a year. Fortunately for Greens, they got an early claim interpretation that they didn't like, and so they went to IPR and they got an interpretation they liked a whole lot better. That interpretation was broad enough to cover that prior art, which means it was anticipated, which means that it covered basically the prior art and was not patentable. So suddenly, the Oil States says, you know, how can we go to one court and get a great ruling, and now the patent office is going to tell us what this is about? This is wrong. We didn't have the right to even present our case to a jury. So what they said was that in the 7th Amendment of the United States Constitution says that in suits at common law where the value in controversy shall exceed $20, and this fracking patent certainly exceeded the value of $20, the right of jury trial shall be preserved. And the idea that because we lost a claim construction in federal court, we don't get a jury trial is violative of the Constitution. So it's a major, major issue. And so the Federal Circuit, the same circuit that had that they set the case up to, had said in another case that patent rights are public rights created by Congress and not by common law. So this becomes an issue of power and, of course, greed. So it's everything that we need for an interesting IPR case, both inter partes review as well as normal IPR. So what does that mean? So in general, a public right created by Congress means that Congress, when it decides to create patent law, can tell you what you've got to accept, whether you get a jury trial or whether you don't. Whether your case goes to the Federal Circuit directly or it's got to go through a district court, it can make up a series of rules. And that's what the Federal Circuit had said in an earlier case. So, the federal court having said that, you would think that that would be over. Ultimately, these patent rights are created by Congress. There's nothing to do about it, right? Wrong. The case went up to the Supreme Court. The Supreme Court accepted certiorari, and so oil states had to tell the Supreme Court in its petition for certiorari that oil states, that patentees are creatures not of statute, but of private rights. So we have to go back to way before the 1790 Patent Act and take a look at whether or not English law, which American law derived from, was going to be relied on. Could you look to English law and find that it was not a creature of statute, but in fact resided before? And that was their position. Oil states said yes. In English law, there was a patent right. It was not subject to Parliament. It came out of the King's power, what's called the Privy Council. And they said, in addition, we've got a serious problem, justices of the Supreme Court. We've got a situation where this patent office is killing patents, and they're killing them one after another. The Federal Circuit judge, who's now resigned in disgrace, Judge Rader, had claimed that the PTO was killing patents like some kind of death squad, that they were just ruthlessly destroying patents, particularly in the electronics area. So if you look at the oil states' brief in their petition for certiorari, they said, quote, "The board invalidates almost 80% of the patents it reviews, almost 10,000 claims through March 2016, destroying $546 billion of the United States economy." Greens had taken the position in its response to the petition for certiorari that Congress can delegate any federal right to adjudication in a non-Article III court, and that patents qualify. And in addition, once it's delegated to an administrative agency, an expert agency, an agency that knows what it's about, it's entitled to deference. And so it should be entitled to deference in this instance, and that deference should be fine under the law. I know that people aren't terribly familiar with U.S. patent law, but there was an earlier case that was decided in 2016 called Suazzo that said that it's okay for the patent office to have a different standard than federal courts do, and that became an issue as well. But the Supreme Court had already said it's okay, so therefore it really couldn't be an issue. But notwithstanding that, oil states asked that it take a second look at Suazzo. So the Supreme Court held an argument November 27, 2017. And so the Supreme Court of the United States actually has 9 justices, and if you count those justices up there, there's some missing. There's 2 of them. One is Judge Kagan, who actually didn't say very much during the argument, so I left her out. Though you see there's a little spot there that I tried to fit her in, but I couldn't quite make it. And then there's Justice Thomas, who doesn't speak at arguments. The case hasn't been decided, so there's no smart solution here. This is just an open question. It's challenges only. So I'm not going to predict what's happening with the United States. But it was an extremely interesting, powerful, penetrating argument that was made by both sides. So those people, the justices who were interested in the notion that patents are creatures of positive law, which means that Congress can act, Congress makes the rules, and if Congress doesn't want you to have a jury, Congress can make that rule, even though it says in the Constitution under the 7th Amendment that you're entitled to a jury trial. The issue is, who is an inventor and what does the inventor own? Does the inventor actually own the invention, or does Congress act first? Well, the Constitution says that patents are recognizable. It allows for enabling legislation. And the Constitution says that the 7th Amendment gives you a right to jury trial. But when do you get that property right? You only get that property right after Congress has passed a law which says you get a patent. You get a patent under these circumstances. You get a patent after you make an application, after it's examined, after it's determined that it doesn't cover the prior art. So in each of those circumstances, Congress has set out the law, and Congress has acted 4 times to set out the law, and it's never been struck down as unconstitutional. So, in the argument, Justice Ginsburg, Kennedy, Roberts, Sotomayor, and Alito all seemed swayed by this approach. In general, Greens had argued that patents, in the Patent Act, you take the bitter with the sweet. And if the Congress decided after hundreds of years of looking at patents in the United States that they wanted to remove certain patents from jury consideration, they could do so, the bitter along with the sweet. Justice Gorsuch, who is a new justice on the court, just appointed by President Trump and has been on the court a little while, made some interesting comments. It's extremely difficult to figure out where he stands on this because it doesn't seem to be related at all to patent law or what the Congress is doing, but has to do with land patents. Anybody know what a land patent is? Actually, I didn't even know what a land patent was until I saw his discussion. A land patent in the United States is when the United States government buys a territory and it becomes public land in the United States. Then the United States has a set of laws where they give out that public land as a land patent, and that quiets the title for anyone preceding it, so that no one else can say, hey, we actually own that land before the United States bought it. So it just doesn't matter because the United States has acted. That can go both ways. Could be favorable to Green's position or could go against Green's position. In my view, and please don't tell Justice Gorsuch, I just don't think he fully got all what the issues were about whether Congress was acting or could act unconstitutionally or not with respect to the 7th Amendment. The words 7th Amendment did not come up in the argument. Not one time. Not one of the justices mentioned the 7th Amendment. Their questions out of the bat were about whether Congress could act, not whether Congress could act unconstitutionally. So it seems to me that we have at least 5 justices that probably favor continuation of the IPR procedure. They automatically assume that you could act without patents. By the way, in the Hatch-Waxman Act, which is a pharmaceutical act that is also a creature of patent law, you don't get a jury trial because you don't have money damages. And that was also established by Congress. So, because I'm a pharmaceutical lawyer, I looked very carefully at that argument, looking for anything that related to that, to Hatch-Waxman. Not a thing. Nobody on either side does pharmaceutical law, so they overlooked, I thought, what was a key argument. But it does appear in some of the friends of the court briefs. In addition, there were some minor points that were made. Justice Ginsburg, Kagan, and Sotomayor talked about the Patent Office having a procedure, needed to have a procedure in place to correct its errors. And if it corrected its errors and it was subject to judicial review, where's the due process problem? Now, that kind of avoids the 7th Amendment issue entirely. Creates another issue, another amendment called the 14th Amendment, saying the government has to act with due process. And so they're not interested in the 7th Amendment issue either. And so, and the other points are too minor to even mention because there are not enough justices that are interested. So, I hate to be on camera making a prediction, but my guess is, and I'm only going to guess, I think that IPRs are safe and that challengers can continue to make those challenges with the Patent Office, and that if you are in the middle of considering an IPR challenge, you should continue to do so. The Supreme Court will decide this probably in the next 60 days or so. So my hope is that it'll be before the video becomes available, in case I'm wrong. Okay. The takeaway, as I said, is that I think both sides took extreme positions in this. The oil states claims, for example, that you can never have Congress create adjudication within an administrative agency like the Patent Office. The problem is that Congress has done it, and it's done it for hundreds of years. And so in the federal in the FCC, there's adjudication of complaints between two parties in something called the NLRB, the National Relations Board, which deals with fair labor practices between an employer and employee, of collective bargaining, over unions. They do that as well. And the FTC also handles complaints from third parties about false advertising and whatever. So it was a ridiculous claim, and I can't believe they could make it before the Supreme Court, but I guess they did. The statute also allowed for an attack on patents much later than the patent issued. And some of the justices, Gorsuch, for example, didn't like that, and Justice Roberts didn't like that, the Chief Justice. And Greens had taken the position that, no, you can do that at any time. And so now I've done a panel on this case before. It's a very closely watched case in the United States. There are millions of dollars that are tied up potentially in IPR cases that are pending and that are about to be brought. And so everyone is thinking about this. And I had a panel member from a member of the Patent Office who's in charge of patent quality. And so the fact that the Patent Office has somebody in charge of patent quality tells you there was a problem of quality at the Patent Office and they need something like this. That the unofficial position at the Patent Office is that this case is as he said, a loud knock that will end with a whimper. And so very interested to see what happens with that. When I talk to people who are in the profession, and in general, I've taken a sort of informal view of U.S. practitioners here, they generally think that IPR is here to stay, and that there's no due process violation. And that's all I have. I have probably a couple minutes, so are there any questions about this? Mario.
I think for my benefit, perhaps for benefit, can you perhaps give it an impression of re-examination versus IPR?
Sure.
2 years and then 1 year?
Yes. So, and this came up a bit during the argument. So prior to the 2012 Act, there was always this thing called ex parte re-examination. And so when you had a situation where somebody who was thinking about a product, perhaps putting a product on the market, they saw a patent out there that was a potential blocking patent, they could bring it to the Patent Office's attention. And the Patent Office could then sort of go back and forth with the applicant. It wasn't an adversary proceeding, just with the applicant to determine whether or not they had made a mistake. And so oil states mentioned that and said, listen, there was another procedure long ago that, of course, respected the rights of patentees, and it was this procedure. And so it was just like a whisper that was said. Somebody blew the whistle on our claim, and then we can litigate it. And we know what the issues are now, and maybe we could narrow the scope of the claim, or maybe we could expand the scope of the claim, whatever it was. And so that procedure was in existence up through 2012. It's actually still in existence. The American Invents Act kept it in place. What is interesting about that are the statistics involved. It was a fairly expensive procedure, but it was not terribly useful in fixing patent errors, at least in the minds of the people who bring those claims. If you looked at the filings, for example, in 2012 to 2013, the ex parte re-examination procedures, the cases that were brought, they dropped in half. And the number of cases that were brought the following year under ex parte dropped again and again and again. IPR has ballooned, and it's become part of the zeitgeist, the spirit over there at the patent office. And so, in general, not many, the board is not conducting these ex parte re-examinations very much anymore. I don't know if have you brought one?
No, I had an ex parte recommendation.
Okay.
I won it. I think that-
Congratulations.
Yes.
It's fantastic. I have never won one of those, and so, yes, yes, which is why, of course, everyone's now turning to IPR. A whole lot easier, right?
Have you seen companies filing continuations a long time in view of IPR that if something happens to that continuation, maybe 5 years down the road, that amend the claims, narrow the scope?
Yeah, so I'm in the pharmaceutical side, and the pharmaceutical side is a whole lot less vulnerable to these IPRs than, say, electronics patents. And so my clients are not doing that. I've not heard of clients doing that because, in general, they feel that the patents that are coming out in pharmaceuticals are of generally good quality. I know that Dr. Ratani is not here. So is anybody here a pharmaceutical practitioner? Anybody? Okay, no? So I can't answer your question for electronics, and that's where you want to talk to somebody in electronics, I think, on the continuation side. Yogesh.
Who is reviewing it? It is the same person or?
No. And it is, so there's a record created in the file wrapper, and there's an examiner that's involved, and there's a 3-judge panel that handles it. And so, in general, what they say is there sufficient grounds to proceed on this? So it's rather similar to the standard for ex parte re-examination. And if there's reasonable grounds to proceed, in general, that they believe that it's likely that one or more of the claims are invalid, then you know pretty much where it's going to go. So these are judges. These judges are destroying patents outside of the pharmaceutical or biotech area. They are, and I think the fact that they're doing that suggests that the examiner quality, particularly in electronics and software, was quite poor. Nobody of your caliber, Yogesh.
Same procedure is there in post-grant position.
Yes, and so particularly with covered business methods are going down at an even higher rate than electronics patents are going down. I think that they were in the 87% the last time I checked. It's a huge number that are getting kicked. And again, it's either non-oversight over the examiners, poor examiner decision making, and just over-ambition on the part of applicants, I think. In large measure, in my view, driven by the existence of these patent trolls out there that were buying up patents left and right, that encouraged people to go forward with stuff that was not really patentable. So it's all about greed. So I'm not seeing any more questions. Thank you very much. It's always an honor.
Thank you very much, Mr. Murphy. That was an extraordinary presentation. As a gesture of thanks, we request Shri S. Chandrasekharan to present the mementos and certificates to our speakers, Mr. Kevin Murphy. And to Mr. Wilson Pinheiro Jabur. and Mr. Padmeen Booch. And to Dr. David Ho. Thank you very much, sir. We extend our gratitude to all our distinguished speakers for giving such excellent presentations. Ladies